In today's video, we're talking about what happens when the founder of a trust dies, because we know as human beings, we're not going to live forever. So it's important that when we're setting up our trusts, we make sure that we we're setting it up correctly so that when we are no longer alive, our trust continues. So that's what we're talking about today. Welcome to this video. So before we carry on that, let me introduce myself. I'm Lumka Stirman, a passionate and dedicated trust consultant and asset protection specialist with a mission to help businesses, investors, protect their wealth, secure their legacy, navigate the complexities of estate planning. With expertise in trust creation, management, and compliance, I work closely with my clients to provide a clear, practical, and personalized solutions tailored to their unique needs. And the other reason why I'm so passionate about this is because when I was growing up, my family had a farming business, a shop, and a security company. And one day something happened in the farming business and they got sued and they lost almost everything because they did not have a trust. They didn't separate value from risk. Everything was mixed up, and that was the biggest problem. But of course, my parents didn't know that then. But since I know that now, I'm passionate about helping other families, helping other businesses separate risk from value so that they don't lose everything like my family did. Why worry about the founder's death? The founder usually sets up the trust and may be the driving force behind it. If the trust deed is properly drafted, the founder's death can trigger confusion over control, disputes between trustees and beneficiaries, costly court or master's office interventions. You don't want that. You want to make sure that you set up your trust correctly beforehand so that you don't have to worry about all of this. What is a founder of a trust? A founder is the person who creates the trust and executes the trust deed. Responsibilities may include determining the trust objects, beneficiaries, appointing or removing trustees, reserving certain powers, rights to amend or wind up. So these are some of the trust's responsibilities, like the founder's responsibilities. The founder is not the trustee usually, although it could be. The trustee holds legal title and administers the trust assets. The founder typically sets the structure, may have reserved powers to but does not manage day-to-day affairs. When the founder dies, trustees continue, but any founder powers may lapse or transfer unless you've set it up correctly in a way that when the founder dies, someone else actually takes over so that it continues without them, so that you don't have to go to court or to the masters in order for it to continue. Because if you're not setting it up before, if you have not set it up correctly beforehand, that will happen. So it's important that you set it up correctly with death in mind so that should the founder be gone, what happens? How does succession carry on? How does continuation happen? What happens when the founder dies? Four key consequences. The first one is founder's reserved powers. If the deed gives the founder power to amend or terminate, these rights usually end on death, unless the deed says otherwise. Like I just said before, it's important to have these set up beforehand. The second one is no change in trustee status. The trust continues with the existing trustees. The trust does not die when the founder dies. The third one is no automatic transfer to estate. Assets in the trust are not part of the founder's estate if properly transferred beforehand. The fourth one, increased focus on succession planning. The need for strong trustee successions, clear trust rules become critical. Like I said, if everything is set up properly beforehand, it makes the transition easy once the founder has passed away. But if it's not, then it's going to be a problem. So you want to make sure that you set it up correctly while the founder is alive, that the trust is set up correctly with all of this in mind. The trust as a separate legal person. The trust survives the death of the founder as long as there is at least one functioning trustee. The trust deed allows for continuity. Trust must continue administering assets, paying tax returns, making distributions according to the deed. That's important that you set up your trust in such a way that as a founder, when you're not around, you still have someone who continues running the trust, like they're still a trustee, and that making sure that you're still administering the assets and making sure that the tax returns are being filed, and that making sure that distributions are happening according to the deed, and that nothing has changed, everything is still being followed correctly. You have to make sure that that happens when you are gone. And in order for you to make sure that happens when you are gone is for you to set it up correctly beforehand while you're still alive. Founders' powers that end when reserved powers terminate. Typical founder powers that usually end on death unless the deed says otherwise: power to amend or revoke, power to revoke or replace trustees. If no one else holds these powers, changes to the trust may require a court or a master's application, potentially higher costs and delays. That's important. If these things are not set up correctly before, it could cost you, because it will also not only cost you, it could also take time, because when you're dealing with the courts or the masters, things are not quick. There's always backlog. So if you want to make sure that your trust is continuing simultaneously and everything just continues without you having to worry about going to court and going to the masters, you must set it up correctly the first time. Risks if the deed is silent, problems when the deed is vague. If the trust deed is silent on who succeeds the founder power hold, how to appoint new trustees, this can lead to disputes between families, trustees, and beneficiaries, applications to the Master of High Court to fix the trust. And that's the way everything drags. That's where potentially you could lose business, because the trust has to be still and stand still and not operate, because you have to go through the master or the high court in order to fix the trust. So make sure that everything is set up beforehand so you don't have to go through all of this. So, types of trusts and the founder. So there's interviewer trust, and there is the testamentary trust. So with the individual trust during is founded during it's created when created it's created during the founder's lifetime, the role of the founder's death, trust continues, founder's powers may lapse. Testamentary trust when created in the founder's will, trust is created only on the founder's death. So a testamentary will is a will that is created once the founder has passed away, whereas the interviewer trust is when the founder is still alive and it continues when the founder has passed away. What trust must do after the founder dies. Practical steps for trustees. Confirm whether the founder had any reserved powers on how they are handled. Check the deed for rules of trustee succession, any instructions linked to the founder's death. Update registration details with the Master of the High Court as needed. This is important. You want to make sure that your structure and everything in your trust is up to date. So it's important that you check all of this and you update as necessary. Pitfalls for beneficiaries. Why beneficiaries should care. If the founder was the only person who could amend the trust, beneficiaries may lose flexibility. Poor drafting can limit ability to adapt to text changes, ability to change beneficiaries or distributions. And that's a problem, because now if you are not able to change these things, it means that you have to go through the master in order to do all of this. So make sure that beforehand, when you're setting up your trust as the founder while you're still alive, you set up these things correctly so that there's someone else that will be able to do these things, so that they don't have to go through the lengthy process of going through the court or the masters in order to change these things. Red flags in existing trust. Telltale signs of trouble. The deed gives all power to the founder with no fallback. No clear process for appointing or removing trustees. No clause addressing what happens on the founder's death or incapacity. These are big telltale signs of trouble. So make sure that in your trust you handle them and you actually make sure that you have answers for these and you set them up correctly. How to future proof the trust. Smart drafting tips. Consider naming an advisor or protector who can guide the trustees after the founder dies, including clear mechanisms to appoint successor trustees, regularly reviewing the trust deed as tax and family circumstances change. This is so important. If you don't do this, then your trust will give you problems when the founder is gone. But if you've got these set up correctly, it will make the transition so easy once the founder is no longer with us. The role of the founders will. The founders will and the founders will can fund a testamentary trust, influence who benefits indirectly, even from an inter vivos trust structured estate. Dying estate can conflict with the trust's intended structure. So it's important that you make sure that when you are setting up your trust, it does not conflict with what's in the will, so that when they work together, when they see what's happening, it actually works together, it actually agrees it's the same thing. So make sure that you set it up in such a way that it makes sense, you know? Ask yourself these questions. Is your founder the only person who can amend the trust? Do you know who your successor trustees will be? Have you reviewed your trust deed since the founder passed away? It's important to review your trust like at least annually. So if something happens and you know that there's change that has happened, like the founder has passed away, a new member in the family has been born, a big business has been bought, and like there's so many things that happen, you want to make sure that you update your trust and that it's up to date and it covers everything. Drop your questions in the comments, and if you like, I can also offer a short trust checklist PDF or a one on one review session. Thanks so much for joining me today. Remember, a well planned trust can outlive the founder, but only if it is drafted with the end in mind. So, if you are someone who has drafted a trust but you're not sure if it has all the proper structures so that it can actually operate beyond you. So like when you're gone, it can still continue. Make sure that you actually book a review session with me so we can check out your trust and see how it is. Or you can get my free checklist. Just send me a message and then I'll be able to send you that checklist. Trusts still offer massive income tax advantages, huge estate savings, protects your assets against creditors, and you can make excellent provision for your dependents in the case of your death. Trusts are important for meaningful wealth creation. It is of vital importance for you to receive advice from a specialist when establishing a trust. It is also important to obtain advice on how to run a trust correctly as once it has been set up. Sorry. So once you've set up your trust, make sure that it is actually set up correctly beforehand. Because once you set it up and you're no longer alive, then it will make it very difficult for the people that you leave behind to be able to get the things as you intended. So book a call with us. A trust is a necessity under all circumstances to protect yourself and your family against financial shocks. Furthermore, a trust builds great wealth. So if you don't have a trust yet and you are interested in creating one, or you do have a trust but you'd like us to review it to make sure that it is set up correctly to operate beyond you. So when you as the founder are no longer alive, it still operates correctly. Make sure that you check out our website, go to lumkastirma.com, book a call with us so we can see how we can help you. Thank you so much for watching. We'll see you in the next video.